Good morning, Chattanooga. This is Jim McCoon, and welcome to Legal Bytes, your weekly legal talk show where we discuss various issues that can affect you and your business and your personal lives. We do this every Wednesday between 11 and 12. I'm glad you're joining us today, listeners. If you should have any questions during our call that you want us to discuss, our number here is 423-800-8949, and we'd be happy to discuss your concerns. My guest today is Clay Whitaker. How are you doing today, Clay?
I'm good, Jim. How you doing?
For most of you out in the public that may not know Clay is a local attorney here in Chattanooga. And Clay, your practice varies from my practice, from the things I do. And that's one of the reasons I wanted you here with me today, is because recently I've been working on a new case where I've got an infant who was injured severely by the acts of others. And, you know, an infant or any child under the, Tennessee follows what we call the rules of 21, which is basically if you're 7 and under, you are by law unable of being negligent or contributing to your injuries. And then, of course, from 7 to 14, there's a presumption that you could not, which can be rebutted. And then from 14 to 18, the law says that there's a presumption that you were competent to commit negligence or be negligent, and it can be rebutted by showing that, you're still immature at the time. So, I'm sitting here and I'm thinking about all these issues, and I realize that we prosecute children every day in juvenile court.
That's true, Jim.
But we're not prosecuting them for a crime, are we?
Well, the law, so the way that our statutes read, we prosecute in the sense that we prosecute because there is a prosecutor there. It's a Hamilton County prosecutor that does handle cases. However, they're not criminal cases. It's a delinquency issue. And so they're not necessarily convicted. They're adjudicated. And so we don't really consider that in the terms that we would ordinarily consider any criminal prosecution. In fact, many of our constitutional rights are not available to juveniles. And so when you say prosecute, it's not necessarily the same thing, but there are some similarities and things we wanted to discuss.
Right. So, all right. So say I've got a 12-year-old that was out at the mall with some friends on a Saturday, and she decides that she really likes some lip gloss and some fingernail polish, but mama hadn't given her enough money. And so she puts it in her pocket and she gets stopped by the store detective. And what happens at that point to that child?
Well, first, Jim, we're assuming that you're talking about one of our local malls and that they are properly chaperoned in accordance with the rules of the mall. And so, anyway, if they're in that set of circumstances, generally what happens is that police officers get called to the scene. Store detectives relate the circumstances. The child may be arrested at that point in time, or the officer has the option of calling the parents, having the parents come get the child, serving the parents with the summons, and the child can be brought to court later. Or if the child is arrested and taken into custody, they can be detained for a period of time. If it's over 48 hours, they're entitled to a detention hearing, and the detention hearing must be held within 72 hours. Most of the time, though, circumstances like the one you described would not result in an arrest. It would result in the parents getting called, the child getting taken by the parents, and then scheduled for a later court date based upon the conduct that we would describe as illegal, as a theft, but which is not a crime. It is a matter of delinquency. Delinquency, the definition of which might result from the technical application of a statute that is a criminal statute in Tennessee, but it has to do with the child behaving in ways that are not socially acceptable, that violate the ordinary standards of decency in our community.
Okay, so that child won't be actually charged with theft.
Well, the definition, so they would be charged, it's true to say they would be charged with theft, but it sounds like we're talking in circles, Jim, but that's the way lawyers do. But it sounds like we're talking in circles. When you're charged with a delinquency, the definition of that crime might be the theft. So let's say that you stole $25 worth of nail polish, as you said before. That's a misdemeanor. The definition of that crime is the state statute, and that's the accurate definition of the proposed delinquency that the child would have. But when it came to the way that the case was handled, you would ordinarily come in, have some arraignment. The court would make a finding as to whether or not there was a finding of delinquency, that is, whether the law was violated, that is, did the child commit a theft. And then the case would be set for an adjudicatory hearing, which is like a sentencing in a criminal case. For an adult, it would be a sentencing hearing. You would be entitled to all the constitutional rights at that point in time through the whole process for the handling of a criminal case. But in the juvenile setting, you don't have all the constitutional rights. For instance, you don't have a right to a jury trial. And as a result of that, the adjudicatory hearing is set, and the judge would find out what the best way to deal with the issue of delinquency is. And it might not result in any detention. The child may never serve what we would consider a day in the jail or in the lockup. That may never happen. But there may be some other things that are necessary to treat the child, which could include addressing problems at home, dealing with school, issues. The court has a number of different options to be able to address particular problems the child may have that were the result, or at least the perceived cause, of the theft.
Now, I had a parent call me the other day and ask me a very astute question, because they were aware of this. And they said, okay, my child can't be charged with a crime because it's a minor under 18. And hasn't been adjudicated to be tried as adult normally. So, my child can't be charged with theft or anything that would be in a true criminal setting. They'd have to go to juvenile court on anything like that. But then my child, if they're speeding, driving recklessly, DWI, they get charged and brought into adult court on a crime charge. Now, how does that happen? How do we divide that up when we're talking about the same 16-year-old child?
Well, our legislature has developed a number of different laws that affect children in different ways. So when we talk about a child, we're talking about a minor that is under the age of 18. There's also the age of 21, which is a different standard for adulthood that affects different kinds of things. But when we're talking about the criminal setting and the delinquency setting, you're talking about the age of 18. So a child under that age typically is going to have to deal with the juvenile court. And if there is going to be a trial in a state court as a result of a proposed criminal case, there has to be a separate hearing to determine that that child has the mental culpability to be tried as an adult. And you mentioned that before. The bottom line is that the listeners may recall, there was that proposal here recently with the so-called Ottawa rape case, where the children that were there were culpable, needed to be handled as adults. So that's the kind of hearing we're talking about. You mentioned the other types of contact with the law that juveniles may have, particularly related to driving offenses, and those have just been specifically addressed by the legislature. They believe that if a child is sufficiently old enough to drive a vehicle and to control it, that they'd be subjected to the laws that deal with moving violations. And you mentioned specifically the responsibility a child might have with regards to driving a vehicle and speeding or being reckless. And those things, we started out this show talking about the different types of culpability a child might have regarding the concept of negligence. And so, moving violations are not always criminal. They can be quasi-civil. And so speeding, for instance, is a quasi-civil case. It's not really a criminal case. And consequently, as a result, you can look at it in terms that the legislature has believed that the issue of responsibility can be addressed in that with a child between the driving age at 16 up to the age of majority at 18.
Okay, so it's de facto, or actually de jure. It's as a matter of law, they are competent to be tried because they were competent to get the license to get behind the wheel.
I think that's true. And of course, there's a number of different sort of steps along the way to see if a child is able to handle that responsibility. Certainly the parents first are sort of charged with that. They have responsibilities. You mentioned parents might be liable for the conduct of children in regards to the wrecks that might occur as a result of automobile accidents from the operation of the vehicle by a child using a family vehicle.
You got a family purpose doctrine. And then, of course, intentional acts or negligent acts by a child can also result in liability, even not involving a car. can result in liability. I believe that it's up to $10,000 in Tennessee by statute for a parent.
Sure. So if any of the listeners are interested in discussing those particular issues more, they can call us at our firm. That's McCoon, Williams, Ashley, and Stanley. And that's 756-6400. We welcome any calls this morning regarding these issues related to juvenile court or to issues related to juveniles that we've been talking about, particularly if it's negligence or other things that you might have questions for. And that's 800-8949, area code 423. Love to take your call this morning.
All right. Now, well, I've got more questions because this is an area, like I said, in your area of practice that I don't really get into. But let's say my child is adjudicated as what you said, delinquent in juvenile court. We think that the evidence was flawed that went in, that the prosecutor didn't carry the burden, and we really contest the issues. Do we have a right of appeal?
Yeah, in our juvenile system, the way it's operating, we've got 3 magistrates. So just for those people who may have had contact with juvenile court, there are 2 juvenile courts. One of them is on 3rd Street, and it deals with issues related to delinquency, the issues related to custody, and the issues related to what we would call neglect, or if a child is dependent in neglect. So those are the 2 primary divisions that we have. The cases that are heard over on Holtzclaw are all child support cases. So we'll just not talk about Holtzclaw right now. That's a whole nother day of a discussion. But the bottom line is that the courts there on 3rd Street, they deal with these issues that we're talking about, which is the question about whether or not someone is delinquent or whether or not there's issues related to dependency and neglect. And so the appeal from those cases, those are typically heard before the magistrates. The magistrates are specifically appointed by the juvenile court judge, which is Judge Robert Filyaw. Judge Filyaw has appointed these magistrates to act in his stead, handling cases for adjudication. And they usually do that, but there's a direct appeal from there to the court in front of Judge Filyaw. You can have a rehearing if you need to, if you don't believe that the proof was, as you said, adequate.
Okay, so it's basically all new. As the term of the law is de novo, but you get a full new hearing before Judge Filyaw if you think that the magistrate who heard it made some rulings that were erroneous, either with the evidence or with his determination of the proof.
That's true, and sometimes that happens. Sometimes the proof, either you had witnesses that you don't believe were honest, or there were problems with the proof, or that the magistrate just got it wrong that day. Sometimes that happens. Everyone is optional. I mean, everyone has the option of having a bad day, as they would say, but you can appeal those things. You can appeal that ruling, and you can appeal the adjudicatory hearing and have a brand new hearing, like you say, de novo. That's brand new from the start, like it never happened before.
Okay. And if you disagree with Judge Filyaw, do you have further avenues?
Well, you can appeal then to the Court of Appeals. And so, I think you've got, at that point, you do have additional options to appeal, but that's very unusual, very expensive, and ordinarily not done.
Yeah, I certainly can understand that. Now, how will the parents first get notified with respect to what is happening in juvenile court? Will they talk with a counselor? Will they talk with the prosecutor? Who will notify them?
Well, ordinarily, if it takes a particular episode. So let's say we're talking about the delinquency issue. So if it's delinquency, the episode that generates contact with the court will probably be with law enforcement. And if that's the case, you're going to have notification at the time of the event that occurred, whatever that would be. And it could be the result of a criminal summons. It could also be a warrant for the child. And that's less common than it is the first one that we've talked about. And then from then on, you're going to have notification while you're there in court. So we assume that you would go to court, you would answer the call, and that at that set of circumstances, you would receive new instructions about when to come back to court. The other way is that the court does send out letters. They send out notification. And if you're involved in cases involving the issues of neglect or dependency, that is, a child's not receiving the care, either physical, the emotional support, or combination of those things, that the court would ordinarily deal with petitions. Those are civil matters, and that the court would send out petitions and notification by mail about when your court dates were.
Okay. And I want to talk about that in a minute, but I want to stay with the criminal side. Does your child in juvenile court have the right to an attorney?
Yeah, that it used to not be that way, but the development of our juvenile court system is really a modern trend. So if you think about it historically, we didn't have juvenile court. So if you went back to England where our law started, you would find that the history shows that children, what we would consider today to be children, were treated just like adults. So the original discussion that we had about, let's say, a theft, if this was jolly old England,
Oliver Twist would be in trouble.
Oliver Twist would be in trouble. He might be in the dock, as they say, and might suffer the consequences of his bad behavior, because it had more to do with the religious concept about culpability or maturity. And so just in terms of that process, it's a modern development of the law. And as part of the modern development of the law, we had to answer the question, what constitutional rights apply to children? We have decided that the right to counsel does apply to children.
Okay. So I'm not able to buy or pay for a lawyer for my child, and my child's been charged with delinquency as a result of theft or vandalism and the like. How do I get a lawyer for my child?
Well, if you can't afford one, when you go to court, you have the opportunity, you explain to the court that the circumstances you're in, financial circumstances, won't allow for the attorney to be hired by you as a private attorney. The court has the option of making a public defender do the work and have that public defender appointed for you to represent you in the case. There are some fine public defenders that are on staff down at juvenile court that represent children, and they do a very good job.
I'm also aware of the fact that if you're a private attorney and happen to be down at juvenile court when they need a lawyer, often the judge will call you to the bench and appoint you to the case.
Yeah, and the public probably is not aware of this, but the attorneys that work here in Chattanooga and in other surrounding areas many times are asked to do work, and to do work at rates which you would ordinarily not accept for payment. And that is part of our duty to continue to assist the public and to help the public with the necessities that are required in life. One of the areas would be in the representation of indigent defendants, and that is part of our duty, is what we call pro bono work. I think it could be. You can also submit a fee payment per the schedule that our legislature has approved, but it is, as I said, far below what an ordinary private attorney would receive in compensation for a case.
So as a parent, I can expect that I'll either get a public defender or I'll get an attorney who believes that part of his service to the community and to the law is to help people like me and my child.
Yeah. And the other part is that when you go to court, you're going to be questioned. You're going to provide financial information to make the determination whether or not the public defender is available to you. If you're able to hire counsel, those resources shouldn't be used by someone just because they decide they don't want to pay for a private lawyer. So be prepared to answer your financial questions. And in advance, the court may tell you that, look, he may ask you, have you spoken with any attorneys? Have you described what the problem is? Have you actually shopped for the attorney? And if you have not, that may be something the court orders you to do. They may pass the case for a short period of time, give you the opportunity to discuss this issue with an attorney. And by doing so, you may or may not be able to pay for that lawyer. But it's like any other service. If you haven't made the attempt to know whether or not you can afford it, then the court may ask you to do that.
Okay. And generally speaking, for our listeners, what kind of range can they expect in the market here in Chattanooga to hire an attorney for a normal delinquency type charge?
Well, it can be anywhere for fees under between $500 and I would say probably up to $2,500. And those are flat rates for criminal cases or the quasi-criminal situation you find yourself in when you're in a delinquency case. But it really is going to depend with the conduct of the child that's been charged. So if it's the conduct that is very serious, what anyone would consider very serious, it can be a lot higher rates. Typically, if you're talking about cases that involve violent crime, those issues may require more attorney time, and as a result of that, you can have a higher rate. If there are smaller issues in terms of what the society would consider to be less serious criminal activity, we don't want to minimize any of that conduct. But that being the case, it would cost you less money.
Okay. Now, from a parent standpoint, do the parents have an economic interest because of their own personal exposure in what happens in the prosecution in juvenile court?
Well, I think so, and it depends on what area we're talking about. But we've already mentioned let's say that you have a child, that child is using a family vehicle. The family vehicle is being driven. The child is intoxicated or has driven in a manner that is reckless, causes an accident, hurts someone. And as a result of that, you can see that the family might have some liability as a result of that conduct, maybe the negligent entrustment of the vehicle, particularly if it's happened more than once. You might have notice that the child, what attorneys say is notice. That is that you could reasonably anticipate that the child will behave in ways that would require additional supervision and for you not to turn the vehicle over to them under certain circumstances. And we could put out a number of different scenarios that you might result in that kind of situation where there may be liability for families as opposed to just for the child.
So even though you may have, despite your love for your child, if you really felt like they need to get a lesson in juvenile court, you may still have some incentive to try to make sure that the findings are accurate and get a lawyer involved, because it could result in the development of proof and charges that could result in liability for the family.
I think that's true. And of course, the different generations have different parenting styles. So for instance, my grandparents' generation might have been a lot stricter. They may have used implements to spank their children, like switches and belts. My father might not have done that, and I might not have done that. But because of those different concepts about the way that you handle discipline, you may take a different view. But I would always counsel parents that, you don't abandon your children when they're in their hour of need, as it were, and that consult with an attorney about the circumstances can result in things that might be beneficial in terms of discipline as well as protecting the child's future. And ultimately, that's what we're talking about, is that you want to make sure that the child's future is protected. One thing that people may have a misconception about is that juvenile records can't be accessed in the future. And I can tell you, I do a lot of work in the federal court system. If a child has a proclivity for, that is, they really like to commit crimes and don't have the self-control that most people need in order to be able to survive in today's world, and that they commit crimes in the future that ultimately result in some interdiction by law enforcement in the federal system, that those previous juvenile court crimes, that what we've talked about meet the definition of a crime, can be used to enhance your sentence in federal court. They're also possible to access them for particular jobs. If you're in an area that requires some sort of security clearance, you might face that those particular offenses might come back to haunt you. So it's always a good idea to have attorneys look at it, try to figure out what it is that needs to be done to protect the kids.
Yeah, I can tell you that just from employment litigation I've handled, that juvenile records have come up and we're actually inquired about on certain applications. So, well, we'll get back to this and other topics on the other side of the hour. I see it's time now for a news break. And listeners, thank you, and I hope you join us on the other side.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM. 3, 2, 1. Chattanooga Radio, AM 1240 and 92.7 FM's news now.
The body of a missing teenager has been found at the bottom of the Sale Creek Bluff. The 15-year-old went missing last night, Tuesday, and was found Wednesday morning. Detectives on scene investigating the circumstances of the death. A man in Brainerd says that a man ran up to him on Sunday and put a gun to his head and robbed him of $800 out of his pockets. He says the man then pointed a gun at the head of his stepdaughter and demanded yet more money. The victim was able to push the robber away, and he escaped in a black Dodge Magnum with a blue racing stripe. That vehicle found by police and pulled over. Lacey Sharkey arrested. The FBI is investigating a case involving a Chattanooga police officer, Brian Moody III, who was under an internal affairs investigation and placed on administrative leave with pay last month. and a few days later he resigned. County Mayor Jim Coppinger says he's doing all he can to prevent property tax increases. The county's right now dealing with $56.6 million in new spending requests. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect some sunshine, hot and hazy weather out there through your afternoon. A little on the breezy side as well. Highs near 90 tonight. Much milder, a little muggier too. Lows mid and upper 60s for Thursday and Friday. Mainly dry with only spotty showers. Very warm, humid. Highs upper 80s. Get ready for Riverbend, June 9th through the 17th, featuring discounted admission at area Circle K locations, savings on tokens at Food City, with more information at their website, riverbendfestival.com. And I'm Sourcine 12 Chief Meteorologist Patrick Ward on Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune Williams and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson, or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta or Greek salad. Jet's Pizza at Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Need a tiller to get things going for the spring? Spiff up your porch, maybe your deck? Come on by and get a pressure washer at Action Rental. Family in town, need some tables and chairs for an event? Come on by and see us. Action Rental. This is Dan at Action Rental on Lee Highway. Come by and see me. Action Rentals.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Well, welcome back to Legal Bytes. This is Jim McCoon. I've got Clay Whitaker with us today. Hello again, Clay.
Hey, Jim.
We've been talking about some of the issues that come up with the liability of children for their conduct that would be criminal in the adult world. And I guess one of the questions that has come up in our off-air discussion was the difference between a delinquent child and an unruly child. Now, is there a difference?
Well, just in terms of the statutory, the goal of the statute, so a child is unruly, it's mentioned in the same statute as the delinquency, but it's a child that's not controlled. And so the court has an approach that they can take. They're able to hold an unruly child for 24 hours, make a determination of whether or not the parent is able to gain control over the child and to discipline the child, behaving the way the child's supposed to behave. So, just in terms of of the delinquency, we're primarily talking about issues related to whether or not there is a specific criminal statute that's been violated. But an unruly child might be a child that runs away, that doesn't stay at home, that no matter what you tell them to do, they don't obey you. And so that causes a whole different set of circumstances. Typically, it results in parents or guardians, custodians calling the court or law enforcement and asking for law enforcement's assistance in picking the child up, holding on to them until they can get them back in the house and reestablish some control over the situation.
Okay. Now, will that result in a delinquency?
Not necessarily, because there's
a juvenile court record for that child.
There's a juvenile court record made, but it's not a delinquency in the sense because you're not looking at a crime. So it's not a crime for a child, or the definition of a crime for a child to run away and not obey its parents.
Right. It's a situation where maybe the single mom who's 5'2", 120 can't handle her 16-year-old boy. It's a big strapping buck that just won't listen to her.
That, or a little smart alecky teenager that runs away and doesn't obey.
Right.
So,
all right. Well, hold on a second. I think we've got a caller. Hold on 1 second. Yes, caller. This is Legal Bytes. You have a question?
I do. I was wondering, when can a student be searched at a public school?
Good question. We had talked about that off the air. There are significant issues under the Fourth Amendment for children, aren't there, Clay?
Well, there are. There's limited protection. And so generally the sphere that you'll find a child in. So when you're talking about the Fourth Amendment, you're talking about the expectations of privacy. So the analysis goes something like this. If you're a child at school and you're assigned a locker or have a bag there, or whatever things may be there.
Or you're on school public property. You've come voluntarily on the public property.
Well, whether it's voluntary or not, Jim, because there's a whole nother discussion about whether or not you're truant. So we can talk about that. But the bottom line is that the school acts sort of as quasi-parental status. So we would say in some legal circles, we would say in loco parentis, but this is at least some quasi-parental status. And so you don't have the full protection of the Fourth Amendment, but in order for the school to search, you have to have some reasonable suspicions that a crime has been committed. Typically what happens is the kids start talking, one of them says something about, let's say they possess some sort of controlled substance. And that gets mentioned to an official there at the school. The official calls in law enforcement, who may bring a dog onto the facility, search a vehicle, search a locker, or ask for permission to search. That's a whole nother topic. But in either case, as long as there's reasonably articulable suspicions, then the search can proceed. And typically you'll find that happening here locally, and it happens all over the country based on that kind of set of parameters.
Caller,
does the child have a right to have a parent or someone with them when something like that happens?
Well, there's no right necessarily. And if you're an active parent, and like there's usually restrictions on things like cell phones, so they can restrict what things you can bring to school. But if you're an active parent, your child calls and says, hey, had a problem here. We got an issue. They want to search. Number one thing as a parent you'd say is don't consent. So, and then the number two things, because consent's another issue I'll talk about in a second. But the second part would be is that parent should immediately go to the school and to try to protect the child as much as possible. So if there's an issue that's related to the search, and for instance, there may be a difference or a distinction between the place search. If it's a locker, you can see that that's one area that's different than if it's a vehicle. The vehicle is not part of the school property. The locker is. The vehicle on the property might require another set of protections, because the vehicle is probably not owned by the child, but owned by a parent. And the parent would have expectations of privacy in the vehicle. Although anytime you're talking about searches for vehicles, there are different standards that are lesser than they are for a home, for instance. Does that explain what you wanted to know, caller?
Yes, it does. Thank you.
Well,
thank you very much.
Appreciate you calling in.
Yeah, thank you so much, caller.
Jim, we were talking about the issue of consent, mentioned it very briefly. So anytime the Fourth Amendment's implicated with a child and as an adult, And so children and adults should get used to this from an early age. We don't have the civics education, at least what I'm seeing in terms of the product. So I usually get the product being defendants that come through the court system. They don't seem to understand the nature of the constitutional rights. One of those constitutional rights is the requirement for a warrant anytime you have a search. So as an adult, if you've had the education as a child about consent and that the Fourth Amendment protects you, that you don't have to consent to a search, which I don't recommend anybody consents to a search, that just in terms of that set of educational opportunities that you might have in school for civics and the ability to explain what the Fourth Amendment is, the warrant is always required. And so adults that I run into don't seem to understand that warrants are required, and they have the sort of exhibitionist, what I call the exhibitionist attitude. That is, I don't have anything to hide. I'll show you everything. And so they do. And that usually causes more problems for them and for representing them in the future.
Well, I have a much broader or maybe even a simpler question. A child, a minor, can't contract. They can't sign a contract. They can't engage in commerce because they're considered to be a minor. How can a minor consent to a search?
Well, and so that is one of the conundrums that we have in our law. And you and I,
that's a big word.
That is a big word. And we have in the font of legal knowledge we're going to try to spew out. We'll try to tear that apart, Jim. But so the bottom line, I think, is that constitutional rights and contractual rights are not the same. They're not equivalent. Constitutional rights are those kinds of rights that are the result of, or what we see recognized by the Constitution. They're God-given, they're natural rights. The rights to privacy is the basis of the Fourth Amendment. And so everyone has a right to privacy, even a child. Now, the question of consent comes in when, and this is what the court says, basically, is that being able to consent to a search really doesn't require a whole lot of, I'm not going to say intelligence, but intellectual capacity. You have to understand that the law enforcement officer wants to search a place, and you either allow them or don't allow them. If you understand that basic English, then you can give consent. And it doesn't require full understanding of the Fourth Amendment right to privacy. However, contractually, there are a lot of things that the contract requires that's a little bit different. You have to understand the nature of the agreement. You have to understand what things are proposed. You have to understand what consideration is. You have to understand there has to be a, quote, meeting of the minds, mutual assent. And many times the intellectual capacity is exactly what's required for that sort of contracting ability.
Well, based upon that analysis, if I have a child, a latchkey child, I guess the term, where, he comes home from school because I'm working and there's no one else at home, and he lets himself in and the police come to the door while I'm at home, but it's after he's come home from school. My 12-year-old can consent to a search of my home?
That might be different because the 12-year-old's expectation of privacy and your expectation of privacy may not coincide. So just in terms, let's just look at it.
I know we're far afield from juvenile, but this is just really amazing to me, what a child can do.
Okay, so adults, let's just take it from the adult standard. So there's a case called Randolph. That is the adult standards that says that basically any adult that resides in a place, the same place someone else does, can give consent to search the whole place. Now, your question was, can a juvenile allow an officer into the home? And the question, I've not seen.
Oh, what's that? We got another call. Hold that thought.
Sure, we'll finish that up in a minute.
Hello, caller. You've called Legal Bytes. Can we help you?
Well, I'm going to make a comment and a question. I'm going to shock you because 99.9% of the people don't agree with me on earth. I don't think anyone can waive their rights, and the courts are all wrong. You can't waive what God has given you. And it disgusts me that the police say, do you want to waive your rights? I mean, can you tell everybody never, ever waive a right? Never. The most powerful word in the English language is no. No, and keep your mouth shut. You're asking me questions to gather evidence against me. If we can just teach everybody that, I think this will be a better country. And every case should go to trial, and the government should have to present evidence, even if somebody confesses. I'd like to hear your opinion on that. I'll listen on the air. Thanks.
Well, my general opinion is this. is that our country was founded on the concept, and you can go back and read whatever particular documents you want to about the founding fathers, whether it's the Federalist Papers or Thomas Paine. There's some other ones you might want to read. There are some that were generated before that were part of the intellectual milieu. That is, the whole concepts that sort of formed our country. The idea is this, that there is no form of government that is not evil in its essence, and that is that it's organized force. An organized force is usually directed against the individual for the benefit of the other persons in that government. If it's a private government, it's for the benefit of the if you want to use the word crown for a king as a private government, you could, or if it was for an oligarchy, some form of government that had a private concept, private formation to it. But if it is for the public purpose, if it is a public government, that is the kind that we have, like a republic or the so-called democracy, those have been seen to be the absolute worst forms of government because it does two things. If you have any wealth in the country, it is subject to seizure by the use of force from the governmental entity. And usually if it's a democracy, it's the same thing that's happened to our country. The reason that we're in trouble is that the people who have the ability to vote from the Treasury also have the ability to use the force of the government to take from the people who have and give to the have-nots. And as a result of that, when you talk about nose being the most powerful word in the English language, it is important, but it all stems from this concept. If you don't think that the government is evil and you don't think that the government needs to be restrained, which is the whole point of our Constitution, is to restrain the government, then you don't see that there's a problem with searching and for consent and for the other things. And if you're in love with the government, then that's the problem, that you don't understand the basic concept that really you need to protect the individual and not the state.
Right. Well, and, it's a balancing. There's a balancing of social justice and social issues versus individual rights. And every case that we run into, those type of issues arise where we're balancing. And so from the standpoint of a very comment you made earlier, is the individuals in our society nowadays never had civics, do not understand constitutional rights, and don't understand where the government's rights end and yours begin. And for that reason, no one seems to have any concept of how to act unless they've hired a lawyer.
And Jim, thanks for balancing me. I was way out there, so
yes,
I appreciate you balancing the other side.
Yeah, I was beginning to worry about where we were going with this radio station. But hold on one second. We have another call. Hello, caller. This is Legal Bytes. Can we help you?
Yes, sir. I've got a question for Clay. Clay, what do you make of the prospect of regulation of Airbnb, which is going to be voted on June 13 by the City Council, the carving up of the city into districts in which, if you're in the district, you can have Airbnb with a special licensing operation, and if you're not in the district, you have to go through the rezoning process, which would bring a zoning fight from neighbors. What do you make of this whole prospect? Can Airbnb be regulated? And I'll listen on the air, okay? Thanks.
Sure. Well, there's no question that Airbnbs can be regulated. The whole nature of our local government is to establish zoning rules and regulations that control the way that property is used. So it really comes down to what your particular political bent might be. If you have a libertarian or anarchical bent in politics, then you would say, I ought to be able to use my property the way I want to, and the government shouldn't be able to regulate it at all. If you are someone that's in the middle, you would simply say, look, you can use your property how you want to, but you don't need to have a set of circumstances that harms me. For instance, if your Airbnb constantly takes up parking on the street or causes problems in the neighborhood, you're bringing in strangers, there might be a rise in thefts, things of that nature, you can see that that group of people in your neighborhood might say, well, we don't really appreciate that. What if you're also causing your property values to go down, and it's demonstrable that before the Airbnb business started, that it was property value X. Afterwards, it caused your property value to go down because you basically have a little hotel in your neighborhood, and your neighbors don't want that. Well, you can see that some regulation might be required. And then you might have the entire opposite end of the spectrum, which is a set of persons that believe that the government should regulate all use of property. And as a result of that, you shouldn't have anything but very specialized districts where Airbnbs can be used, and that it shouldn't be all over the place. You only can use them in a certain place. And that's a strict zoning regulation that would require those folks to have a particular approval by an authority from the government so that you don't impact on your neighbors and that it's controlled in the terms of your property use.
Right. It's nothing more than the NIMBY syndrome we've seen in the environmental field for years, not in my backyard, NIMBY. And the reason why is because, we all need hazardous waste facilities. We need some place to handle this regulated material and get rid of it for us, but nobody wants it next door. And it's the same way with these Airbnbs. People are concerned about how they're going to affect it and what the government's trying to do by setting up districts and then requiring zoning activity in the other areas is trying to balance land use. And like we had the same thing in our noise ordinance, where if you're near a church or if you're near an elementary school, you're stuck to certain decibels. The same with liquor sales. And even if you have one of those where you have the liquor catered, if you're in a certain area of the city or if you're within so many yards of a school zone and like, you have issues.
And so basically local government, as we would say, is the best form of government because you have more control over it. If you want to get the pitchforks and the tar and feathers out, you can do that. And you can certainly go and have your voice heard locally. We also, as part of that sort of process at our law firm, represent people in zoning cases. We'd be pleased to represent anyone who was faced with these issues related to the use of Airbnb or other property use issues.
All right.
756-6400 is our law office. McCoon, Williams, Ashley, and Stanley. Love to talk to you some more about these issues.
Now, we've gotten very far afield from where we were with respect to the juvenile issues and consent of minors.
Yeah, completely forgot what we were talking about, Jim.
I'm telling you, it's been an interesting show today. A lot of topics covered. But from the standpoint of the minor issues, there's a lot that goes on in juvenile court that beyond what we've talked about. One of those is termination of parental rights.
Yeah, typically the termination of parental rights, and as I've mentioned to you during the break, Tennessee's a state that protects parents' rights. It's an important thing. We obviously need parents. We need children. We won't have a state if people don't have children and don't raise their children properly. And so it's an important job, one that should be respected, both whether you're a stay-at-home dad or whether you're a stay-at-home mom and whether you have the opportunity to do so. Certainly we would promote those things. But the state of Tennessee, through the Department of Children's Services, does have a statutory authority that if you fail to take care of your kids, there is a way that they can terminate your parental rights. That is that you would not be able to have a relationship, a parent-child relationship. So you think about this, this is one of the most fundamental rights that anyone has. But we've given the authority of the state to interdict that relationship, to stop it, and to prevent you, for instance, termination of parental rights would prevent you from visiting with that child. It would affect whether or not you would actually have any relationship with them, whether they could inherit from you, whether you would be able to follow their life in terms of their school, or whether the circumstances would be about health care, any of those kinds of things. So it can be far-reaching and very, as we say, a fundamental right, very, very important right, terminated.
Yeah, and from that standpoint, those actions are brought by the state itself, or can individuals bring those claims?
Under limited circumstances, the state can, the individual can do it, but they're primarily done by the state of Tennessee through the Department of Children's Services. As we talked about during the break, it takes 4 months of ignoring your child, not paying child support, not participating in their life, no visits in that 4-month period. That's the statutory grounds to allow the state of Tennessee to file a petition against you, but typically it's going to require some other bad conduct on your behalf that showed that you did not care for your child. The child has been dependent and neglected in some fashion.
Right. And it can go beyond just taking away one parent's rights. You can take away both parents' rights and put them in foster care.
Yeah, but because it is an essential constitutional right, just in terms of the actual termination, it's one of those things that is individual to each person.
So, well, it's been a very interesting topic, not only with the Airbnb issues and on zoning and districts, but also juvenile court and the rights of minors. Clay, thank you so much for joining us.
Thanks for having me, Jim.
Listeners, I hope you enjoyed the discussion today. It's varied, but it's been interesting. And we'll meet with you next Wednesday, 11 o'clock, to discuss new issues and new topics in the legal field. This is Legal Bytes. Jim McCoon, your host, and we'll see you next week.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights in future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time in your life. Clay Whitaker, 756-6400. I've been a customer at S&S 14 years. It's way out of my way, but I'm well treated. I believe what I'm told. Price is reasonable. David Tulis here. Make an S&S appointment today. This week, get $50 off any 30,000-mile service or timing belt repair. And get a free combat knife as a gift. S&S Auto Repair specializes in Toyota, Lexus, Honda, Acura, Scion, Nissan, and Infiniti. 6-time winner of Best of the Best Award in the Times Free Press. 855-3436. ssautorepair.net. 855-3436.
McCune Williams and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of